All rise. First District Court of Appeal is now in session. All who have business before this court draw near, give attention, and ye shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Please be seated. We have two cases on the docket scheduled for oral argument this morning. Our first case is Alachua County Board of County Commissioners and Alachua County Supervisor of Elections versus Keith Perry, Kimberly Hoard, Jose Lopez, and Charla Head. Counselor, you're ready to proceed.
We are, Your Honor.
You may approach. We will allocate 20 minutes per side for the oral argument, counsel. Would you like to reserve some time for rebuttal?
I'm going to try to reserve 5 minutes, Your Honor.
So noted, Madam Clerk. You may continue, counsel.
May it please the court, I'm Peter Webster of Carlton Fields, and I'm here on behalf of the Alachua County Commission and Supervisor of Elections. With me at council table is Sylvia Torres, the Alachua County Attorney. Because we believe we prevail on the statutory construction issue, I'm not going to spend a lot of time on subject matter jurisdiction unless the court has questions. We believe we've adequately covered that issue in our briefing, and so we'll rely on the briefs absent questions from the court for the court to decide whether the petitioners fled the existence of an actual present bona fide dispute requiring the trial court's intervention, or whether they merely pled a request for an advisory opinion based on the possibility of legal injury if the referendum passed in November. With regard to the statutory construction issue,
Oh, I'm sorry, I do have a question
Yes.
on the jurisdiction part. So as Justice Polston indicated in his concurring opinion in Roberts versus Brown, circuit courts routinely consider pre-election cases when there's a constitutional challenge. Here, the trial court resolved the issue on statutory grounds. Is that the distinction that you think is important here?
Well, first of all, Your Honor, I think that Justice Polston was concurring and dissenting in the Roberts case. He was the sole dissenter. And I think if we read his opinion carefully, we find at page 686 that from his analysis of the election cases you adverted to, he was pretty clearly of the opinion that the majority was saying, in its opinion, that you just can't seek declaratory relief in those kinds of cases. So I'm not sure that the opinions that the petitioners relied on survive subsequent to the Roberts opinion.
Do you think he was limiting that to, or the majority at least, to citizen initiative petitions where the Supreme Court does have a special place?
I don't think, Your Honor, that that's the way Justice Polston was reading it. What Justice Polston said, and this is at page 680 of the opinion. Oh, I'm sorry, that's the majority opinion. What Justice Polston said at page 686 of the opinion, after he discussed the cases you mentioned, he said the majority justifies its decision in part by referencing the rule of law that a circuit court does not have jurisdiction to render an advisory opinion based on hypothetical facts. So he's clearly reading the language at page 680 of the majority opinion as stating that you can't attack these kinds of referenda, whether citizen initiatives or just normal referenda, pre-election because of necessity You're seeking an advisory opinion based on facts that haven't yet occurred and, in fact, may never occur.
But didn't the Supreme Court in 1958 in the Dade County v. Dade County League of Municipalities case, I mean, I don't understand how they got there after following Duval County versus Jennings, which was a special case dealing with receivership of or conservatorship of trust funds. Be that as it may, they did say in the subsequent case in Dade County that they basically that seemingly approving looking at this stuff pre-election, because they called it, what was it, vain and useless thing if it was an invalid proposal in the first place or proposition in the first place. So I guess going back to Judge Ray's question, is it the constitutionality versus something else that's the distinction there, or where are you headed with that? I know that you said that you've already covered this in the briefing, but I think it's an interesting issue.
It is, Your Honor, and I'm not sure that the Dade County and Duval County cases survive Roberts, but assuming without conceding that they do, and that you can still challenge a proposed ordinance, if in good faith you claim it's unconstitutional in its entirety on its face, that's not what we have here. While the petitioner's arguments are all over the map in the trial court, the only two constitutional challenges that can be fairly read from the emergency petition both relate to Article 8, Section 1G of the Constitution, which says that the governing body of a county operating under charter may enact county ordinances not inconsistent with general law. Their first challenge in their petition was that the proposed amendment would violate general law because, and this is a quote, Section 124.011.3a only authorizes the Board of County Commissioners to submit a proposition calling for single-member representation and does not authorize the board to submit a proposition calling for at-large representation. Clearly, on its face, that assertion fails, so it's not a good faith assertion. And it clearly fails because 124.011.10 clearly provides that a county choosing to opt for single-member election districts can opt back.
But what's the difference, though, between when you're looking at the constitutionality of something? Typically, we're looking at a Florida statute and questioning whether it's constitutional. So you have the superior law, the Constitution, and the junior law, the statute, and there's a conflict between the two, and you have to resolve that conflict. That's Marbury versus Madison and everything since then. But when you're looking at a local government and you have an ordinance, and there's essentially a conflict between the ordinance and a Florida statute that the Constitution provides is superior, and I'm not, that's a separate question, but assuming that there's superiority between the statute and the local ordinance, what's the difference? It's still a conflict where that has to be resolved.
Well, first of all, there is no conflict between.
I don't mean to.
There is no conflict between the ordinance and the Constitution, because the ordinance, if passed, would simply provide for a return to at-large elections.
Right. But what about the ordinance and the statute that we're talking about? So if there's a conflict between the two, and the argument is that the statute prevails, it's the same analysis as if you were looking at the constitutionality of the statute.
To the extent that they have pleaded a problem between the ballot referendum, not the ordinance, the ballot referendum, which we submit is not what you should be considering. But to the extent they argue there's a conflict between the ballot referendum and the statute, that only exists if they're right that Section 124.011.9 applies to a decision to go back to at-large voting. And we think it's pretty clear, for the reasons I'd like to get to, that that's facially not a valid constitutional issue either, because it's clear subsection 9 does not apply here.
Counsel, I believe I understand your issue regarding the statutory challenge, but the petitioners also raised a constitutional challenge in the proceedings below. Is that correct?
Are you talking about their claim that the local bill is irreconcilable with what was done?
The trial court.
Their third issue?
The trial court particularly said that it did not reach the constitutional issue raised by the plaintiffs below. Regarding your jurisdictional argument, would the trial court have had jurisdiction to grant injunctive or declaratory relief in this case had it found a constitutional violation in the referendum as opposed to a statutory violation?
Well, I've already discussed the only valid constitutional arguments they made in their petition. They made a whole bunch of additional constitutional arguments in a supplemental memorandum that they filed the night before the hearing, to which Alachua County and the Supervisor of Elections objected. And so those issues have nothing to do, we submit, with whether there was a valid constitutional claim made, because they're not part of the petition. And maybe that's what you're talking about.
Specifically, did the trial court have jurisdiction to reach a constitutional issue in this case, assuming for the sake of argument that the plaintiffs raised a valid constitutional issue?
Assuming for purposes of argument that the plaintiff asserted it in its petition a valid constitutional issue, that the ordinance, the proposed ordinance, would be unconstitutional on its face and in its entirety, the court may have had jurisdiction to consider that. The older cases seem to suggest it would. We submit to you that Roberts strongly indicates that's no longer the case. But my point is, even if that is still the case and the court would have had jurisdiction, there are no good faith arguments in the petition that the ordinance, the proposed ordinance, on its face and in its entirety would be unconstitutional.
Did the legislature have the authority to enact the special law that was raised by the appellees?
I don't know the answer to that, Your Honor. We're assuming it had that authority for purposes of this appeal.
So in that special law, the legislature directly amended the county's charter, right?
No. They amended it effective as of the electors voting by majority vote to make the change.
Right, the conditional amendment.
Yes.
And has that gone into effect now?
It did. As a matter of fact, in the 2024 general elections, 2 of the county commissioners were elected in single-member districts.
Right, but the special law that been, sorry, I forget the bill number, but the enactment from
1493.
Yeah, from 2022. That law is now in effect, isn't it?
Until pursuant to section 124.01110.
Yes, and that's my question. So, are you prepared to argue whether the county voters, the county commission and county voters, can override a direct special act of the legislature amending the charter?
I am prepared to argue that, yes.
Can you explain why that might be, and then what is the point of the legislature having political subdivisions in the state of Florida?
Sure. First, petitioners made the same argument in the trial court. The trial court rejected that argument, concluding that because of section 124.01110, the commission could again place the issue on the ballot for a return to at-large elections. Petitioners didn't challenge that in the trial court. They've not taken a cross appeal here. In fact, in their answer brief, they state the trial court was correct. Therefore, they've waived any argument that the special act prevents a return to at-large voting. Secondly, they fail to identify any specific language in the bill which supposedly conflicts with the referendum, because there is none. The referendum clearly does nothing more than direct that the matter be submitted to the Alachua County voters. That was done. There's nothing in the special act to suggest that they couldn't return, if they wanted to at-large voting. And in fact, if the special act did that, it would almost certainly be unconstitutional in violation of Article 8, Section 1E of the Constitution, and of course would be irreconcilable with Section 124.01110, which expressly provides for a return to at-large voting. Third,
Counsel, what is the practical effect of an affirmance of the trial court in this case?
an affirmance on what ground, Your Honor?
Just affirmance. If we affirm, what's the practical effect?
Without any analysis? If you affirm without any
That's correct.
analysis, you know, that I presume that the 2024 election would be considered invalid, and single-member districts would still be in place. But, you know, the statute that the trial court relied on simply does not require that the language in subsection 9 be used to return to at-large voting districts. The subsection 10, which is the controlling provision, expressly states that a county adopting one of the propositions set forth in this section may thereafter return to the procedures otherwise provided by law by following the same procedure outlined in subsection 3. The petitioner's argument is that although that's what the statute says, it can't really mean that. It must really mean that you can return to at-large voting only by complying with all of Section 124.011.
Then, counsel, is it your position that Section 124.011 does not provide any required language if a county wishes to revert to at-large voting from a single-member system?
That's exactly our position. And if the legislature had intended to require a county wishing to return to at-large voting districts to comply with all of the provisions of Section 124.011, why on earth would it not have said, instead of what it did say, which is you can return by complying with subsection 3, why would it not have said a county adopting one of the propositions set forth in this section may thereafter return to the procedures otherwise provided by law by following the same procedure outlined in this section? They used section when they meant to refer to a section, but they used subsection 3 when they said what had to be complied with. And the reason for that is because there's already a provision in the Florida statutes that deals with referenda and the wording of referenda. It's Section 101.168, and it's entitled Ballots and Referenda.
Thank you, counsel. You're well into your rebuttal time.
Thank you. I'll reserve what I have left.
May it please the court. Good morning. It's a little bit daunting to try to inform this august body about statutory interpretation but I'm going to do my best to enhance the analysis from the briefings. And in particular, just to give you one keyhole to look at this statute through, and I think
Counsel, regarding statutory interpretation, what authority says that a trial court may grant the declaratory relief in a pre-election case based on a violation of a statute as compared to a violation of the Constitution?
so. In the briefs, we cited a string of cases where circuit courts have challenged the wording in ballots and initiatives, not constitutional citizens amendment initiatives. And we can presume that the number of cases reflected in the DCA opinions is just the tip of an iceberg of cases that either were PCA'd or weren't appealed at all. So it's a commonplace procedure in Florida. But the statute is a ladder. The statute has a little front door, two sections, subsection 1 and 2, and it's got an attic, which is 10 and 11. And subsections 3 through 9 is a ladder. The first two subsections relate to the conversion between at-large and single-member districts. It's appropriate that they would come first. The statute was written initially when no counties were single-member districts. It was the only way you could get there. And so every county that wants to go to single-member districts has to first proceed through subsections 1 and 2. Up in the attic, you have 10 and 11. That's what happens after you've completed and you've gotten to single-member, and you might want to go back. But 3 through 9 is the ladder. That's the process. You have to step on every rung. And if you look at the language, you will see that's exactly what the legislature intended. It's unmistakable. Once you see it, you can't unsee it.
Yeah, but actually, isn't it the opposite? Like, when I look at 9A, what I see is it is part of the initial process, and that's what, so when it says each to be elected from single-member districts, to be elected in the future after the transition. So it's speaking in the future, if the county follows this process and then they go to single-member districts, if you want to then, at that point, that's when 9, so 9 applies initially, not subsequently.
That's a fascinating point, and I think that really goes to the sort of beautiful symmetry of this statute, because that language goes either way. The legislature didn't come up with a whole bunch of different configurations. They came up with one set of language that voters can either say yes or no to, and it works either way. It's bi-directional. And that's part of the magic of the ladder, Your Honor. If you look at sections 3 through 9, you will find not one reference to unidirectional language. You can't find it. It's not in there. In some cases, they have to be a little inelegant even in the language in order to accommodate both directions. So, for example, they call it the proposed revision instead of the petition to shift to single-member districts. They use different variations and synonyms for that, but they never specifically reference going either one way or the other. There's some more magic language if you want. If you
I mean,
look,
subsection 3 does.
subsection 3 describes how the shift is initiated, either way.
No, it actually says a proposition calling for single-member representation.
Well, that's true, and that's the transition sentence.
So that's going one direction.
That's the
That's
transition
the initial
sentence.
process, which you've described, that's, you know, the...
The latter.
Yeah, the latter part.
Yeah. So we know that paragraph in particular was intended to be bidirectional because that's the one that subsection 10 sends you back to. So
Well, I mean, the reference is to the process that follows the initial statement in subsection 3, not the whole subsection 3. The whole subsection 3 doesn't talk about the process.
well, that gets us into
Paragraphs A and B do.
Yeah, that gets us into the fascinating language of subparagraph 10, which I'll cover in just one moment. So what you see, if you look at that language in the ladder that I described, is you see a very, very careful adherence to directional neutrality. You see symmetry. You see a process that is described from 3 all the way through 9, starting with the beginning, working through the intermediate steps, and finishing with the ballot right before the election. So there's a timeline that's built into that ladder as well. Just like when you go up a ladder, I think there's even a sticker on it that says you have to don't skip rungs. And so the legislature drafted it just that way. It's very logical.
Well, that might be the case, but why doesn't 10, under your reasoning, reference subsections 3 through 9, but instead only reference 1?
Okay, so here's where it gets crazy. I would argue that it does. And in order to show you, and again, I think once you see it, it's really hard to unsee. And my esteemed counselor just read the whole section. I won't reread that, but I'm going to focus on these magical words. By following the same procedure outlined in subsection 3. There are words in that phrase that become surplusage if we interpret it to mean only follow the requirements of subsection 3. In fact, you could probably strike that entire phrase if you wanted to get to the meaning of only following subsection 3. So they could have said by complying with subsection 3.
Did the trial court consider subsection 10 in its ruling below?
I don't believe that the trial court mentioned subsection 10 in its ruling. I think the trial court focused on subsection 9 correctly. And that's
Let's digress
because
back to the jurisdictional issue, if you will. Did the trial court essentially acknowledge that it was issuing an advisory opinion when it observed that applicants could seek declaratory relief after the election if the referendum passed?
that comment was, in the trial court's order dicta because it followed a very explicit sentence saying that the ballot language did not comply with the statute, and that was not hypothetical and was not advisory. So if you look back at that language I was just focusing on,
Can you, oh, go ahead.
by following the same procedure, what does that mean, the same? Why not just say the procedure, the same procedure? So that's one interesting statutory interpretation question. The second point is they used the word outlined. Not by following the same procedure in subsection 3, but the same procedure outlined in subsection 3. What does outlined mean? What is an outline? An outline is an overview. And if you look at subsection 3, and in particular subsection 3A, you will see that's the one where it describes the county initiating the process. That sentence ends in referencing the word ballot.
But why is it more reasonable interpretation of subsection 9A to be that it applies only when the county is attempting to go from an at-large system to a single-member representation?
Well, Your Honor, I think for all the reasons that I just mentioned, I believe that the language in subsection 9 is expressly bidirectional. And to supplement that, to give you more evidence that I'm right, and I think you'll agree with me, if you look at subsection 5, where it outlines the language for petitions, that is in citizen-initiated processes, it is also bidirectional.
But
So
isn't-
it works for either
But
way.
isn't subsection 10 the only provision in section 124.111 that expressly addresses when a county wishes to revert to an at-large voting system?
I'm sorry, Your Honor, I didn't
I'll
catch.
repeat the question. Isn't subsection 10 the only provision in section 124.011 that expressly addresses when a county wishes to revert to an at-large system of voting?
Did you say expressly?
Yes.
Okay.
That expressly addresses when a county wishes to revert to an at-large system of voting.
Yeah, I would agree. That's the only spot in that section where it expressly refers to reversion to at-large, but I would argue that subsections 3 through 9 all implicitly address it.
Can I ask, I mean, instead, I mean, I'll be honest, I find this argument to be your weakest argument. The one that I'm actually interested in is what I was asking your opposing counsel just before. Is there any special status? So this, I mean, I know that the voters had to approve it. That's, Article 3 allows for that, and the legislature provided as a condition for the charter amendment to go into effect. It had to face the voters first, and it was approved and added to the charter. But that's still the legislature directly amending the charter
Yeah.
via special act. Do you think there's any special status to that kind of amendment to the charter versus a county commission approved charter or proposed charter amendment that goes to the voters? Otherwise, like, what's to prevent a biannual back and forth between the county commission and the legislature? And I think that there are reasons for why the legislature did what it did, and it has the authority to circumvent the county commission, arguably. That's why Article 3, Section 8 has an exception for charter counties. Otherwise, we're in this situation where every 2 years, so the legislature passes another amendment to the charter, and then the county commission, and it's approved, and then the county commission comes back and puts it back to the voters the other way, and you're just going back and forth.
Yes.
But is there any legal authority
Yeah.
to place a legislative amendment to the charter in some sort of special status?
Your Honor, I apologize, that wasn't a direct issue in the case, in this appeal, so I didn't dig into that. I share your questions about those issues. I would say that this court doesn't need to reach the outer boundaries of what HB 1493 accomplished, or what the state's preemptive powers were with regard to HB 1493. The only issue I think that this court needs to reach with regard to this appeal, and this goes to our third tipsy coachman argument, is did the local government subvert the state's implied intent by immediately reversing the voting method in Alachua County?
Well, that's why I'm asking. I mean, you did
Yeah.
argue it in the.
Right,
How-
and let me approach it this way. Perhaps it violated the spirit of the special law, but how did it violate the law itself? I mean, I think you acknowledge in your answer brief that 10, the reversion component of the statute's still in place, right? The trial court said that as much.
I don't think that in good faith we could argue that that HB 1493 intended to preclude for all time the county's ability to revert. But the state obviously wanted Alachua County citizens to enjoy the benefits of single-member districts for some period of time. The question is, and I think that Alachua County is implying that because there's no explicit language forbidding them from doing what they did, then it's okay. But that shifts a burden onto the state that might be too much of a burden. The state's not required to anticipate every way that a local government could get around or subvert its intent. That's just an impossible burden. So, in any case, if the county did any kinds of dirty work at the crossroads or whatever, that's, our point of view, we would be right back here and the county would be making the same argument. Well, HB 1493 doesn't say we couldn't do this. So that's why implied preemption exists, I believe, so that we can look at the reasonable intent of the state's action and compare it to the local government's conduct to determine whether there's been an illegal subversion.
But I'm still not getting how 124.011 the entire process could apply in a situation. I mean, 124.011 was designed, as you, I think as both counsel explained, it was designed to facilitate counties going to single-member districts at a time when there were no counties that had single-member districts. And this was the process they had to go through. Okay, that's fine. That's not this situation. In fact, you have a situation here where the legislature told the county, we're amending your charter. And that's the way it's going to be, subject to the vote of the, subject to a referendum. But assuming the voters approve, that's the law in the county. So even though it faced a referendum, and even though it is effectuated as an amendment to the charter, it is still a special law. It has, it's in the books in the Department of State. It's an extant special law, which seems to me to be in place until the legislature repeals it.
Correct. I agree.
In fact, the Florida statutes, the Adoption Act, it accepts special laws from being repealed. So it is still in effect. And how can it be that a county commission could override a special act by ordinance?
We don't believe that it can, is the short answer. We believe that it was a subversion of the statute. The challenge is that the county has, invoked this statutory process that isn't directly
Sure.
referred to in HB 14.
And so getting to that, you did obtain a judgment from the trial court, and it said that the proposition is invalid. But it passed. What is the status, what does that judgment mean? What is the effect now? And I'm assuming you did not seek any supplemental relief, or maybe you did. You're not seeking any review of that. So what's going on?
Yeah, so I believe that the trial court's order explicitly provides that in the event the voters approve the reversion, that we can seek additional relief in joining the supervisor of elections, or, getting some other post-election or prior next election relief. But
there has not been an election yet under the...
next year. The results of this election are suspect because they were clouded by the judicial decision that was well-known in the community. So who knows how many voters didn't turn out because they relied on this judicial order.
Counsel, I'd like to digress for a moment back to the appellant's statutory interpretation argument. If the legislature wished for any provision other than subsection 3 to apply to a change from single member to at-large, wouldn't it have said that in subsection 10?
I believe that it did say it. I believe it said it when it used those magic words that I told you about, that would be surplusage if we interpret it any other way. And that is by following the same procedure as outlined in subsection 3. That's where I think it was in the answer to your question. Regardless, I see I only have 1 minute left. If there are no further questions from the panel, I would like to thank you very much for having this opportunity to be here in this beautiful courthouse. And have a good afternoon.
Thank you, counsel.
Judge Tannenbaum, first, with regard to your concerns regarding whether the county could revert to single-member district voting notwithstanding the special act, all I can do is emphasize that the petitioners have said that the trial court correctly concluded that the county could return to at-large voting by using the mechanism in 124.01110. They've not challenged that below or here. In fact, they say that was correct. They've clearly waived that argument. In addition, it's noteworthy that amicus, which claimed to have had a role in both the passage of the Special Act and in the 2022 referendum campaign, also acknowledges that the county can revert to at-large voting by the procedure in 124.01.110. Now, with regard to the statutory construction issue, let me just say the language of subsection 10 couldn't be clearer. It uses section in the first part of the subsection, but uses subsection 3 in the second part. And it says the procedure in subsection 3. The procedure in subsection 3, all you have to do is read subsection 3, and it says that the proposition can be put on the ballot by one of two manners. That's the procedure they're talking about, either by a formal resolution adopted by the Board of Commissioners or by citizen initiative. Finally, let me just say, there is no way you get to the result petitioners want you to get to on the statutory construction issue without ignoring the plain language of subsection 10 and instead inserting for subsection 3 in subsection 10 the word section. Thank you.
Can I ask?
Yes.
So, do you deny that a special act of the legislature has the same status of law as a general act?
I think in general, the law in Florida considers the two as two different things. If you look at Article 8, Section 1 of the Florida Constitution, you'll see that the first sentence of 1G talks about general or special laws, but the second sentence, the very next sentence, just refers to general law. The sentence that says they can pass ordinances that aren't inconsistent with general law.
And that's one of the special statuses of a charter county as opposed to an
It is, yes, sir.
non-charter county.
Thank you.
And thank you, counsel, for your respective oral arguments. Our second case scheduled for oral argument this morning is New Venture of Destin LLC and Damon Beckno versus Civil Shells Property Owners Association et al. Counsel, are you ready to proceed?
Yes, Your Honor.
You may approach, counsel.
Thank you.
Again, we'll allocate 20 minutes per side for this oral argument. Would you like to reserve some time for rebuttal, counsel?
I would, Your Honor. 7 minutes, please.
So noted, Madam Clerk. You may continue when you're ready, counsel.
Good morning, Your Honors. Raymond Rafel, representing New Ventures and Damon Becknell. This is a situation where the court has entered an order, as the court is well aware, on a motion for summary judgment. There were actually 2 motions for summary judgment heard at the same time. There was a motion for summary judgment that was heard by the appellees and also by the appellants. The appellants was denied. Everything that's in my brief, in the event that I do not address those in the reply initial brief, we're reserving as to those with the arguments. And of course, if I don't address it in oral argument, we are not waiving that. So the issue that we have, Your Honors, is that, number one, the standard of review is de novo. And there's de novo in this case for not only the summary judgment, but also the construction of the declaration, which of course is the contract, but also the backbone of our condominium laws. So in this particular case, what the court did, in our opinion, was, number one, granted summary judgment when it should not have done that in the lack of evidence that was presented. The other is, of course, we believe that the court misconstrued and misinterpreted the declaration and the amendments to the declaration. And then finally, the court also, and this goes to another de novo, misapplied the law on relative to what we call the Fourth Amendment. And I'm going to address that because that seems to be the flag that's often waved in this case, which is my client did something as to fraud because the date on the amendment was not the date he signed it, and a notary signed it at the same time when there was, in fact, a different date.
Before you get to all of that, can
Yes.
you address why there's jurisdiction here, how this qualifies as an appealable non-final order?
Yes,
I mean, it's an order granting summary judgment on 3 counts, one unfortunately labeled injunctive relief, but I mean, we talked about this case, or we talked about a similar issue in the city of Newberry versus Alachua County a few years ago, talking about just granting of summary judgment on a count that, as part of its relief or prayer, seeks injunctive relief, is not the same as ordering an injunction at that moment. So can you address
Yes, I'll address that. It's our opinion, Your Honor, and of course, subject always to your rulings, that this is a situation where it's not only just an injunction, but an immediate possession of property.
Sure, I mean, it's the same thing. I didn't mean to put them in the same category. So it's, the count 3 sought injunctive relief. Generally speaking, you're characterizing this as immediate possession of property. I'm assuming, I mean, I looked up the CCIS, there's been no bond filed, there's been no stay sought, there's no threat of actual execution on any sort of order of immediate possession. And presumably that's because you don't have a final judgment yet, as the trial court itself said in its order.
Well, in the order, it did grant them the right to immediate possession of the property.
Granted the motion for summary judgment and said that there would be a right to immediate possession. It's a granting of the summary judgment. There's no judgment here on which to grant a remedy, which is typically required. You have to have a judgment first before you get a remedy. And this is not a temporary injunction situation, so there's no order of keeping the status quo that you're appealing. You're appealing the merits of an interim summary judgment that happened to, if it becomes final, would result in injunctive relief, which is different to me.
I understand what you're saying. I disagree respectfully because you're saying, well, the next step is you get the same judgment with the same language, and I don't believe that's necessarily what the order does. I believe
Well, after you have the trial on the other 2 counts, I saw that there was a notice for trial filed, and so the case is still pending There's still trial awaiting for 2 counts. It's not over yet. And so what is the, right now, there's just a summary judgment granted. It's not granting any relief. Are you under threat of, have they sought to transfer the property and force the summary judgment at this point?
First of all, they have not done that yet. That doesn't mean that's not something that they will do. They will do that.
How would they do that on a partial or interim summary judgment?
Well, I believe that this order is a partial summary judgment order for final. I don't agree that this is a aspect relative to they get to come back. What is there else to do?
Well, I think the trial court actually explicitly declined to enter final judgment. It reserved ruling, and it said I'll enter final judgment after these remaining counts are resolved. And I came across a case that's pretty similar out of the 3rd DCA, where the court said the trial court simply granted the motion for summary judgment but did not enter a judgment or issue a writ of possession. Therefore, there was no jurisdiction under the narrow circumstances of 9.130. I'm similar to Judge Tannenbaum. I'm having a hard time seeing our jurisdictional basis here.
Okay. Well, I understand what you're saying. Number one, I would say that nobody has argued that, so I'm coming in a little, less prepared than I would have liked to be. I'll be quite honest with you. With regard to that, and I'm looking at the order now, is what I'm looking at, just so you understand. I don't necessarily, it says the court will enter final judgment on these counts, which is what you read, Judge Ray, on these counts upon resolution of the remaining claims in the case. So to the extent that you believe that this isn't, for them, they cannot go and get a deed, or because this is what the injunction orders, is for us to give them the property, and this is, in fact, an order in that point, I believe that the court, that requires, if they did enforce that aspect, that we would have to do that. The final judgment is based on, it says, on these counts upon resolution of the remaining counts. The remaining counts.
But wouldn't you then have relief? You could come to us, seek a writ of prohibition or something, because the trial court can't grant relief, can't give you a remedy until there's a final judgment. That's what a final judgment is. It's the actual relief. It's the end of the case, and it changes the legal relationship between the parties and creates obligations. There's no judgment right now changing the relationship or creating obligations. There's just an order granting the motion and explaining why it's granting the motion.
Right. So again, I don't disagree with you, Judge. The aspects, though, is that where we are on this is you're basically saying, okay, you have a grant of a summary judgment. We're going to wait until the court hears one other count, which is on the aspect of their claim of a fraudulent document that was filed, and then 2 other counts that they've already tried to move forward in the trial court to say because those were abated because we had this, what we call the sandbar case, which is also up on appeal here in front of the court. And one reason that we haven't, I presume, you can ask them, is because the sandbar case, if it's overruled by this court, then affects this case. If it's not, then it becomes almost a res judicata aspect to a certain extent. There are some things that are slightly different, but then they would do that. They've already moved for the unabatement. Yes, Judge?
No, I was thinking, it seems to me like if you have to order granting summary judgment, then the case law says typically it's not appealable.
It's true. We just viewed this as a aspect of when they granted it and ordered that it would be, because the injunction, of course, being there's a negative and a positive that's an injunction, were to do something when they granted that injunction that we are now supposed to provide the property to them. We believe that that was an injunction with immediate possession.
Well, but count 3, I mean, it's labeled injunctive relief, and I question, well, what are the elements of a cause of action for injunctive relief? Injunctive relief is a remedy. It's not its own cause of action. So which count 1 or count 2, is was injunctive relief being sought.
It's count 3 is what they have.
Yeah, but count 3 is not, it can't be a standalone count. So even though it stood there and no one said anything about it, there are not elements to a injunctive relief cause of action. Injunctive relief is a remedy tied to a cause of action in some way, statutory, common law, something. So is it the declaratory judgment count, or is it the breach of contract count?
Well, I disagree.
Or
that
is this
it-
a specific performance labeled as injunctive?
That's what
relief
we
count?
argued. We said, this is not injunction. This is specific performance that you've called an injunction because you're requiring that we provide you with the real property. That's our argument, because we also address whether that in fact is under a statute of frauds, statute of limitations issue, because of course, you know, it's a 1-year statute of limitations. So we have said that you call this an injunction, but it's a specific performance, which is what we addressed in our brief too. However, the court, regardless of what it called, and again, I don't agree with the trial court's reasonings or the law or anything like that. It adopted almost substantially the Pelley's order, which again, we didn't agree with. So in this case, it says here, according this court will enforce the plain language of the declaration and requires, this is where we get this, and requires New Venture to transfer title to all common properties listed in the declaration as of the year 20-year date, May 27, 2019. And then it says these are it, so this order does require that we are supposed to transfer. I don't disagree with you, Judge. I think it's a specific performance, but that's not what the judge ruled. And I do know that there are specific counts for a permanent injunction that are standalone. They didn't necessarily allege that. Again, I agree with you. This is a specific performance, but the court did order us. And I understand you say, but, you know, Rafel, we got to have a final judgment. I don't disagree with you on that either. However, with this, the reason being that we're here is because it's requiring the transfer. Have they enforced this order yet? They have not. Can they enforce this? I believe they can, which is why we're here. And if we didn't file this and we didn't come here and we didn't say this was wrong, I believe the next step would have been knocking on my client's door saying, where's our deed?
Right, and then you'd have something you can do, because there's interim relief, which is typically to maintain a status quo. That's really the full scope of a trial court's authority pre-judgment, is to just maintain the status quo and control the parties. Cannot grant interim relief before there's an adjudication of the facts and a judgment entered. You don't have a judgment entered. You have an interim motion for summary judgment that was granted that ultimately will lead to the entry of a judgment. I don't know why you didn't seek a partial final judgment if what you're saying is that there's just one other count and it's regarding a separate party, and this qualifies as a partial final judgment. But that's not why it's here. It's here because it happened to be on a count that is labeled injunctive relief, I assume.
Okay. I think it would not be prudent of me to go and get a judgment against my client for this, to be quite honest. I don't. And when I have an order that says you will transfer, then to me that's an immediate possession. So perhaps you disagree with the process, and I understand that, and by all means, you are the judge. But at the same time is when I've got an order that tells me what exactly I read, and it says transfer title, that to me means that this court has already adjudicated. And when you look at this and you say, okay, what else, Rafel, does this need to be done? Okay, what other judicial work needs to be done on counts 1, 2, and 3? According to this, nothing. Because the court says we don't have the time for you already took it out. Now we have the aspects of the turnover, which we believe is the wrong thing. He says turnover occurred. You were supposed to do this. We find that turnover already occurred. Now, because of this, and to your point, hey, count 3 is not really an independent count, but to your point, count 1 and 2, he grants 3. And then he says here to transfer all title. So if I look at this as which is what we did, We said, this is an order of immediate possession because it doesn't say transfer upon a final judgment.
Well, so I cut you off at the beginning when you were talking about standards of review, but now we've come full circle. So if it's only the injunctive relief part, or the specific performance, as you would call it, or the ordering of your client to do something immediately, wouldn't it just be count 3? And what is the authority for us to then be considering counts 1 and 2? And typically, when we're considering injunctive relief in an interim or an interlocutory order, maintain the status quo, we have a standard review for that. But that's not going to apply here. You want us to look at all the merits of the whole thing before it's a final order. So how are we supposed to approach it if we take it your way?
Because you can't get to 3 until you have 1 and 2. So you have to, if you did this logically by math, to come up with the number 2, you'd have to have a 1 plus a 1 equals 2. This you don't have. You can't have that. There's not, if you say, okay, I agree now, argument-wise, that this is an appealable aspect. How is this error then? Because you have to look at 1 and 2 to see how the court got to 3. So back to your point, Judge, if you find that this is not, because I still think it's a specific performance count, but if you come to and you say it's just an injunction count, then you still have to say, well, that's a relief. What was the relief? Immediate possession. How did he get it? Because of what he found on turnover. So why I think that, and I'm familiar with the aspects of the appellate review, which is if it's tied to an issue that is permissible for the court to determine, the court can look at the other issues that may not have been reviewable on their own. But because the court did what it did, this is where we are. This is why it's an immediate possession. And I submit to the court that that has not been raised at any point by by the appellee.
Counsel, this is not meant to be a gotcha, the jurisdictional question.
I don't think so. I think it's a good question. I wish I had prepared.
Well, no, I mean, and you're obviously well prepared. The briefs were excellent by both counsel. It's just jurisdiction is something that we have to continue to assess, and our jurisdiction in an interlocutory review is quite narrow. And so I appreciate the references to the order that you believe, rise to the level of immediate possession of property, and that's just something that we need to assess when there hasn't been a final judgment and when there hasn't been a writ or anything that the court could execute or their client could execute on by virtue of this order. So that's just something we're struggling. It's not intended to be a gotcha.
No, I certainly did not take that. I mean, I've been doing this long enough. You should have some idea of everything that's going to happen. And I do think it's a good point, considering that we considered that point to start, because it's very well known that the granting of a summary judgment until it's changed by rule is not an appealable aspect. So what we did is, of course, we did evaluate that. So it's not something that, I certainly don't think it's a gotcha. I certainly do not. But it is something that we considered. And I do think that based on this, we have the right appellate review. I would reserve, I'm not sure what for, but I'm already at a loss. Thank you.
You may continue, counsel.
Thank you. May it please the court. My name is Kent Seyfried with the law firm of Holtzman Vogel on behalf of Appalachia Silver Shells Property Owners Association. Like my colleague, I was here to obviously discuss the merits of the case and make that argument, but in light of, I guess, the jurisdictional questions, that needs to be addressed first. And I think with respect to the questions, it's a valid question. I don't think there is jurisdiction here with respect to this summary judgment order because there is no final judgment. To that point, how does that get remedied or cured, obviously we go back to the trial court, we get a final judgment that basically says the same thing it says here, except with a title of final judgment.
And dispose of the rest of the case.
I'm sorry?
And dispose of the rest of the case or characterize it as a partial final judgment, right?
That's correct, Your Honor. And so we could be back here in that same posture with a partial final judgment where the court have jurisdiction. But
Is that your position, that everything has been disposed of as to these parties?
No, Your Honor. With respect to, there's two more counts, I
I mean,
believe.
there's the Reformation count still. isn't there?
That's correct, but I think by if counts 1 through 3 stand and are affirmed, the Reformation count is moot, I believe.
Yeah, but see, you're highlighting, you're both highlighting why we have the rules that we have regarding final orders and non-final orders. The 9130 is not intended to be a backdoor way to get review for the benefit of the parties so they know what to do with the rest of their counts. You filed a complaint, you have a number of counts, one of them has not been resolved, or two of them have not been resolved yet. Don't you need to finish the case and then get a judgment, and then, someone can come up to us and ask for a review of the whole thing?
Yeah,
And
that-
one wrapped up in a bow.
Yeah, you're absolutely right, Your Honor. It does need to get finished, and my client is wanting to get this case finished and finalized and have, one appeal and be done with it.
The trial court could have done a partial final judgment on counts 1, 2, and 3, is that correct?
I'm sorry?
The trial court could have entered a partial final judgment as to the counts on appeal,
He could have, yes, sir.
Well, that's
and
what I
that would
was
have been
just-
appealable.
In my opinion, yes, Your Honor.
But that's what I was just asking you. I mean, the Reformation count, count 5, I understand, that seems to be completely separate. Not completely, but it obviously deals with a separate issue regarding one of the parties. But count 4 is Reformation about the same documents that counts 1, 2, and 3 are about, isn't it?
That's correct, yes, sir.
So help me understand how there could be a partial final judgment as defined by the appellate rules when you have a count outstanding related to the issues that counts 1, 2, and 3 are related to.
I can't explain that, Your Honor. I agree with you that it's not a final judgment in this
Right, but it
case.
couldn't be a partial final judgment either, because you have one count, count 4, that relates to the parties that are here on appeal now, the appellants, and the documents that are at issue that hasn't been resolved, disposed of, or dismissed.
I'm not sure exactly about that, Your Honor. I have to go back and look at that reformation count, but my memory serves to say that count dealt with the Beach Amendment to reform the document to invalidate the Beach Amendment, and that Beach Amendment that was executed, I believe, in 2001, 2002, has been resolved by the settlement with Silver Shells LLC. That's why I said earlier, I think maybe that equitable reformation count is moot at this point.
Still, we have sake of argument that we affirmed the trial court in this case. What is left for the trial court to determine in the proceedings below?
The only thing that's left, Your Honor, is count 5, which is liability under section 817.535 that goes to the fraudulent fraudulent execution and recording of the 2019 amendment that attempted to remove common property from the condo association after turnover occurred. And that was a document that was signed or dated January 1 by Mr. Damon Becknell, both in the document and in the notary jurat. And that was done sometime between February and July 1. Nobody knows when it was done. The notary signed that document knowing that that date was fraud. And so that's the count for liability and damages relating to that is to be tried.
And against whom would that judgment, against whom are you seeking that judgment?
It would be New Ventures, it would be Damon Becknell and the notary, Mrs.
So the same
Corfonta.
parties, so at least two of the parties that are present now.
That's correct.
On appeal.
That's correct.
So I guess and those facts that seem, or at least somewhat related, imagine some of the evidence that you would rely on for count 5 show up in the 2,000 pages of appendix for counts 1, 2, and 3, right?
That's correct, Your Honor. And there's also counterclaims pending by New Ventures that deal with the declaration as well, that will have to be resolved.
Can the parties go back to the trial court and get an appealable final judgment as to the appeal counts?
As to these three counts,
Yes.
I wouldn't think so, based on the arguments here today.
Well, I'm not making any arguments, I'm just asking the question.
Yeah, if the court doesn't view this order as requiring, the immediate transfer of property as counsel argued, then no, it can get there will be no final judgment on counts 1, 2, and 3, in my opinion.
Can you explain what count 3 is? I see practitioners do this, I've seen it for 20 years when I was a civil litigator. Why is there a separate count called injunctive relief? I've seen counts where there's a count for declaratory judgment relief. Is this, what is count 3?
It is a count entitled injunction, but I think Your Honor is right, and my colleague is right here. It really is a remedy of specific performance upon the breach of contract claim for count 1. I inherited this case about on the third amended complaint, so I did not draft these original counts, so I can't give you specific insight as to why that count was drafted like that.
But if it were really, in reality, a specific performance remedy being sought, it would be tied to count 1?
It would be tied to count 1, which is breach of contract, wherein the trial court found that New Ventures breached the declaration by not transferring these two pieces of common property at turnover, which was May 27th, 2019. And its failure to do that, the remedy is transfer it now.
But does that cause a problem? Because count 1 seeks compensatory damages, which seems to be, unless I got that wrong, maybe it was a previous complaint, but I think count 1 seeks compensatory damages for breach of contract. Can you seek specific performance and compensatory damages for breach of contract at the same time?
Yeah, I think you can for the damages for the temporary time period in which you did not possess the land. So our unit owners have been dispossessed of that land from 2019 through whenever time the court orders or the actual property is turned over. So yes, I think you can recover both during those timeframes.
And how much in damages has the trial court given you?
They didn't award any damages with respect to counts 1 through count 3. I think the court was granting the injunctive relief there on count 3.
Are
Possession
you
of the
still
property.
seeking compensatory damages? Is that going to be a subsequent hearing where the trial court's going to have to resolve it?
I don't know, Your Honor. I don't think so, but maybe. I'll have to go back.
I mean, you
and
can
look
see
at the
all the
pleadings.
problems that develop when parties come to this court mid-case to have certain legal issues that they're interested in having resolved. I mean, for me, there's lots of loose ends that could be problematic if, we were to rule on the merits of one part without knowing how the case is ultimately going to end. But I've beaten the dead horse. I've beaten the dead horse, clearly, so I will stop asking about it.
Understand, thank you.
Before you sit down, again, what's to prevent the trial court, assuming for the sake of argument, that we dismiss this appeal for lack of jurisdiction, from entering in the position of the law an appealable, partial, final judgment as to the appeal of 3 counts?
Well, I think what the argument is here, and again, I haven't researched this and prepared for this very question, but I think there's other interrelated counts, both in the counterclaim as well as still left, count 4, the equitable reformation, if it's not moot, that might prevent the trial court from doing that. So without going back and looking and researching it specifically, I don't know that I can stand here today and say that the trial court can or cannot enter a partial final summary judgment on these 3 counts.
And I didn't focus on it before, but do any of the counterclaims seek an offset, a sort of counter compensatory damages that would serve as an offset in the case if they were successful?
No, I don't
Maybe a
believe.
question I should ask.
I don't believe any of those counterclaims would. There's a counterclaim for seeking to invalidate a amendment that the SSPOA made after turnover, so that's unrelated to counts 1, 2, and 3. There's also a slander of title count still pending on the counterclaim, which alleges their title was slandered by our Les Pendens when we filed it with respect to the two common properties at issue.
Are they
But
seeking
no, I don't think there's any
damages for that?
So, Yeah, they are seeking damages for that.
Right, so if they were successful on that count, that might serve as an offset on any damages you were seeking on count 1?
Well, they can't be successful on that count if you affirm counts 1 and 2 and 3 in this case, because they're saying the less pendants on that common property slandered their title. The judge has ruled for us saying we're entitled to that property, so that count would arguably be dismissed, consistent with counts 1 and 2.
Sure, but as we stand right now, what is the status of their counterclaims?
It's pending. If there's no other questions, thank you.
Sure. I think you have some rebuttal time left.
So the equitable reformation deals with the same properties for the court's benefit. That's at count 4 of theirs. Count 5 is completely separate, dealing with what we say is a non-issue on the date. And we've said, but if the court is concerned, because I hear Judge Lewis, and he's correct, a final order is when there is nothing left for the court to do. And why didn't we do a partial final order, a final judgment? Also very good questions. There's nothing left to do because you can't have compensatory and specific performance. And as the court's aware, specific performance is permitted for real estate because it's of a unique character. That's what they sought. That's what they obtained. If the court still has issues with whether this is an immediate possession or appealable, then would the court entertain an Ortenis motion to reserve and relinquish jurisdiction for a partial final judgment based on the counts 1, 2, and 3, again, count 3 being what it is, and then we can proceed forward in that regard, because I do appreciate that our clients have put in substantial fees that we've charged and everything, and I do think that where we're going to end back up is even if we go back to court and get the judgment, we're still going to come back on the same issues. So I would just ask the court if they would entertain that. That would be appreciated, at least by my clients.
Thank you, counsel. We'll take it under advisement.
Thank you very much.
This concludes our oral arguments for this morning. We are adjourned.
All rise.